to immigrants.
Please take your seats. So we're resuming the hearing. I'd like to give the floor to the public prosecutor. I shall continue where my colleague left off. We will now explain which applications we will be making with regard to further investigation. On certain points, we will also explain that we seek no further investigation because we do not believe that it would be adding anything meaningful to the case. And we will explain this because we believe that the defense and your court may possibly take a different view. By indicating at this early stage the areas in the case file where further investigation may be considered, we would like to facilitate the progress of the investigation. We would also believe that this will help the court arrive at its opinion. After all, the court itself has a responsibility to ensure that the trial is sufficiently comprehensive, and you can also order further investigation. We're applying for further investigation only in the case have not requested such investigation. There is a practical reason for such parallel investigation. Because of the difference between the trials in absentia of Girkin, Dubinsky and Kharchenko on the one hand, and the defended action involving Pulatov on the other. If further investigation in the case of Pulatov is simultaneously allowed in the other cases, in the cases against the other defendants, it could lead to a situation in which the other defendants who are currently abroad have to be notified in writing about various investigative activities, particularly adhering, witnesses pursuant to Article 226b, paragraph 1 of the Criminal Code of Criminal Procedure, and the expert witnesses, Article 228, paragraph 1 of the Code of Criminal Procedure. So, by experience, we know that formal information to the other defendants will be very time-consuming and hardly ever successful, and this would lead to unnecessary delay. Based on the case file, we have to assume that the other three defendants are aware of this criminal trial and have decided consciously not to participate in it. If investigation in the case against Mr. Pulatov should result in information that is relevant to the cases against the other defendants, that information can be added to their case files too. Any exculpatory information will in any event be added to their files. If the position of the three defendants should change in the future, and they should wish to participate in their trial after all, they can still invoke all of their rights as defendants. Until such time, we will submit applications for further investigation only in the case of Mr. Pulatov, and we would request your court not to order further investigation ex proprio motu in the cases against the other defendants. We will now successively discuss the next categories. further investigation of MH17. Intercepted telephone conversations. We've just explained our comprehensive approach to validating the intercepted telephone conversations that Ukraine provided. As far as the Public Prosecution Service is concerned, the authenticity and content of the intercepted calls have hence been investigated as fully as possible, using different methods. We do not rule out any further investigation, but we only consider that it would be meaningful if it were based on serious and concrete, specific new information about the intercepted telephone conversations. As to the question as to whether new information about the intercepted telephone conversations does or does not warrant further investigation, it's necessary to look very critically at the source of that new information. Specific accusations of manipulation are, for example, contained in a report by the Malaysian investigator A. Rosen, which was published online. The investigation team analyzed this report and added it to the case file. There are a number of things that are quite remarkable. Rosen investigated videos posted on YouTube, and they were posted there by the SBU. In these videos, we see fragments from intercepted calls, and in this investigation of Mr. Rosa is not an investigation into the intercepted calls themselves. It leads, for example, to the very unsurprising conclusion that the conversations in the YouTube videos have been edited. That conclusion is undoubtedly true, but it says nothing about the complete intercepted conversations that are contained in the case file and that have been thoroughly investigated. Rosen writes, on the one hand, that access to the original material of the intercepted calls is necessary in order to be able to draw conclusions about their authenticity, and that he does not have access to that original material. And then, subsequently, on the other hand, he draws several conclusions about the authenticity of the conversation fragments. We cannot reconcile these assertions. And then finally, Rosen labels at least one conversation as being fake and not authentic. But one of the participants of that conversation has publicly confirmed that he took part in that conversation. This is a conversation of a certain Kozitsin on the 17th of July 2014. Separatist Kozitsin, in an interview with a journalist from Vice News, acknowledged that he took part in that conversation, and he explains how, in his view, this conversation should be interpreted. Our conclusion at this stage, based on these findings, is that Rosen's report may say something about the clips in the YouTube videos that he investigated, but this report does not provide any compelling reason to question the authenticity of the intercepted conversations included in the investigation. A specialist in forensic speech analysis from the Netherlands Forensic Institute informed us of the ways to investigate the authenticity of intercepted conversations, referring to Rosen's report as an example of how not to go about this task. This NFI specialist says the following about Rosen's report. A proper investigation of authenticity must be carried out on the basis of a specific manipulation hypothesis and, where possible, using the alleged original recordings. Rosen's report fails to comply with either of these principles. The report's findings, therefore, have no relevance for the question regarding the authenticity of the underlying intercepted telephone conversations, and in Rosen's report we see no reason to apply for further investigation. We acquired among specialists about how further investigation into disputed intercepted conversations could be carried out in a meaningful way. Now, the following picture has emerged. General accusations of manipulation, such as the contention that all intercepted calls have been falsified, cannot be meaningfully investigated. Specific and concrete information can be investigated. If such information comes to light, preferably as a result of a suspect adopting a specific position on an intercepted conversation attributed to him, there are several ways in which this could be investigated. Technical investigation of alleged anomalies or abnormalities, such as noises that can be heard or background noise that is lacking, for instance, that can be carried out by forensic experts. More technical further investigation into the authenticity of conversations could be conducted, for instance, by having a Russian-speaking forensic audio specialist assess one or more conversations regarding issues such as possibly illogical sentence structure or word orders in the sentences that were spoken in the intercepted conversations. And such an investigation could possibly be carried out in one of the Baltic states. We expect that Russian-speaking forensic audio specialists can be found there who can carry out an investigation into this case with sufficient impartiality. And then finally, it also would be logical to perform tactical investigation into the disputed conversations. And this means analyzing with reference to other information from the investigation whether, in the light of the conversation's content, whether there's reason to believe that a conversation has been manipulated. In short, we're not applying for further investigation into the authenticity of intercepted conversations in the case file because we believe these conversations have been investigated sufficiently. At this time, we see no information that is sufficiently specific to cause doubt with regards to that authenticity. If nevertheless an intercepted conversation is disputed in a sufficiently specific manner on the basis of a serious source, we will gladly express a view on what kind of meaningful investigation thereof can be performed. In order to facilitate the progress of these proceedings, we've already reflected on a meaningful further investigation, how it could be performed. In view of the time of such further investigation, it's important that a decision be taken on the matter as soon as possible. And therefore is especially relevant to ascertain whether the defendants, and Mr. Pulatov in particular, are disputing specific intercepted conversations. This brings me to the video material. The file contains 7 videos and 3 pictures or photographs of the teller. According to investigation, they were made on the 17th and 18th of July 2014 in eastern Ukraine. On the basis of one photograph, we've already explained how we validated these images. And once again, further investigation is only meaningful if there are sufficient and specific indications that these images have been manipulated. The Russian Ministry of Defense has argued that a number of these images have been manipulated, and this was the case at a press conference on 17 September 2018. This allegation of manipulation provided food for thought. With regard to a video of the teller in Luhansk, the same Ministry of Defense on the 21st of July 2014 had said that the image was accurate, but that the recording had not been made in Luhansk, but in Krasnoyarsk, a town that was under control of Ukrainian armed forces. That assertion was based on an address that was on an advertising boarding. On the video, the address cannot be seen. Geolocation techniques, drawing on specific characteristics of the video, revealed that the video had indeed been made in Luhansk and not, as claimed by the Russian authorities in their press conference, in Krasnoyarsk. At the press conference held 4 years later, the location of the recording was not discussed. And this was not the first turn of the Russian Ministry of Defense. On the 21st of July 2014 and 26 September 2016, it offered contradictory interpretations of the same radar plots. First, it claimed that there were reflections of a Ukrainian fighter aircraft, and subsequently it said it were debris of flight MH17. At the press conference on the 25th 1st of July 2014, the Russian Ministry of Defense also presented satellite photographs purportedly showing a Ukrainian book system that disappeared from view near Donetsk prior to 17 July 2014 and reappeared on 17 July 2014 at Zaroshenske and disappeared again a day later. In doing so, it suggested that the disappeared Ukrainian book system was responsible for downing flight MH17. Satellite images from the European Space Agency and Google Earth and meteorological investigation of the KNMI, it has been demonstrated that the Russian photographs could not have been taken on the dates claimed. And therefore there was every reason to be skeptical about the Ministry of Defense's latest allegations in 2018 that the images of the tailor had been manipulated. Anyone who falsifies evidence and repeatedly produces contradictory versions of events cannot be considered to be the best source to evaluate the authenticity of other evidence. Nevertheless, these images and the Russian claims concerning them were referred to the experts of the Dutch Forensic Institute. And according to the NFI, the Forensic Institutes, there are no indications that these disputed images were manipulated. Shortly before this hearing, we learned of new Russian accusations of manipulation. They're included in the written statement of the Russian Federation, dated 31st of December 2019, in a proceedings before the European Court of Human Rights. These proceedings were initiated by various next of kin, victims of the downing of flight MH17 against the Russian state. In its written statement, the Russian Federation asserts that other images of the tailor were also fake, even alleged a series of manipulated images, a false digital story. The Russian Federation's written statement presents various images, with the exception of a photograph and a video of a teller moving under its own power in Snitsne. These images had already been mentioned by the Russian Ministry of Defense and were investigated specifically by the NFI. In that investigation satisfactorily refuted the Russian claims. According to the NFI, there were no indications of such manipulation. That leaves us with the photograph and the video of the teller in Snitsne. They have not been disputed before. Various comments are made about the photograph and how it was exhibited in the JIT presentation, but the statement does not explain why the image itself was allegedly fake. Specific alleged indications of manipulation are only mentioned in respect of the video in Snitsne. We have asked ourselves the question as to whether these claims warranted further investigation of the images, and specifically we considered how far we should go in validating images, what further investigation into image manipulation would add to the investigation that has already been performed, and how seriously we can still take the Russian accusations in the light of all the demonstrable untruths already propagated by the Russian authorities in recent years. Nevertheless, we feel that at this very early stage of the proceedings, it still makes sense to have this specific example of alleged image manipulation investigated by experts. If such an investigation begins promptly, it need not hold up the proceedings. This investigation has only examined metadata in original image files, such as photographs and videos. Investigating other files would have served no purpose because metadata can change when resaving, sending, or uploading files on services such as YouTube. And in such cases, metadata shed little light on when an image file was created or modified. The Russian Federation's written statement in the proceedings before the European Court of Human Rights, it is claimed that a YouTube version of the video of the teller in Snitsne gives as an encoded date 16 July 2014, which then would be one day before the downing of flight MH17, and the making of the other images of the teller. The Russian Federation argues that this encoded date can never be earlier than the date on which the video was actually uploaded, and consequently, the video must already have been uploaded on 16 July 2014. This does not tally with the findings of the investigation. We can point to other evidence from various sources of a teller moving under its own power through Schnitzner on the 17th of July 2014. We also wonder why a video which, according to the Russian Federation, was manufactured with a propaganda motive on the part of the JIT was made on a date that is not consistent with the alleged propaganda message. And at the same time, expert knowledge is needed to respond to the substance of this point concerning the encoded date. The NFI report referred to earlier does not address this new question, and we would like this point to be referred to an expert. In brief, as regards investigation of photographic and video material, we see grounds for an application for referral to the examining magistrate to order an expert examination of the video of the teller in Schnitzner. Specifically, this would be an examination into the following: possible indications of image manipulation of the two versions of the same video of the teller in Schnitzner included in the case file, partly in the light of the claims made by the Russian Federation. Second, the contention that the version referred to by the Russian Federation of the same video must already have been uploaded on 16 July 2014 and hence must have been recorded before then. We will now discuss further examination of witnesses by an examining magistrate. We have already explained that we are now making applications for further examination of witnesses because of the expected preparation time that will be required. In this regard, moreover, we're expressly reserving the option of applying later during the pre-trial review for more witnesses' examinations. First, we'll indicate what the security issues are surrounding the further examination of witnesses, and then we will set out in respect of several witnesses the grounds on which we are applying for them to be examined further. We will always refer to witnesses as he. If the identity of a witness is protected, it is possible that a female witness is being referred to, so whenever we say he, it must be understood to mean he or she. The procedure. We've already explained why the examining magistrate has decided not to include the identity of dozens of witnesses in the case file, the threat from the DPR in eastern Ukraine, and the fact that the Russian Federation is going to great lengths to conceal its involvement in this case have significant consequences for the investigation activities that have yet to be carried out over the coming period. Every effort will have to be made to ensure that witnesses can be heard safely. Safe examination of witnesses whose identity has been protected on the orders of the examining magistrate will not be possible in court. We must be mindful of the fact that anonymous witnesses can only be safely examined by an examining magistrate without the defense and public prosecution service being present. After all, in view of the nature of the threat, the mere fact of the time and place of a witness examination becoming known could give rise to an unacceptable security risk, and that risk does not arise if the examining magistrate hears a witness at a time, over an extended period, and in a manner unknown to others, on the basis of written questions from the public prosecution service and the defense. Previously, the examining magistrate considered it necessary to remove from the case file the dates of the interviews conducted under Article 226A of the Code of Criminal Procedure, because those dates could provide clues to the identity of such witnesses. And that risk will be no different now. The Public Prosecution Service considers that the examining magistrate is ideally placed to decide how new witnesses can be heard safely, while at the same time ensuring that the defense can exercise its right to examine witnesses. The examining magistrate is in possession of most of the information and has now acquired considerable experience in examining threatened witnesses in this case. Referral to the examining magistrate will in any case be required in respect of all witnesses whose identity has been protected under Article 149B of the Code of Criminal Procedure, because an assessment will have to be made of how they can be examined in a manner consistent with the earlier decision to omit their identity from the case file. It would not be logical for the panel of judges hearing this case to designate one of its own members as an examining magistrate. If it were subsequently to be determined that the defense counsel and the public prosecutor may not be present during examination of witnesses, which is to be expected, then the judge from your bench will no longer be able to take part in the trial, the hearing, and this has been stipulated by law. And if your court should take cognizance of information that for reasons of security cannot be added to the case file, you would find yourself in an unfortunate situation in which you would know more about a witness than the defense does, which strikes us as being undesirable. And therefore the Public Prosecution Service would express its opposition in advance to the possible designation of an examining magistrate as being one of the judges hearing the case. If the examining magistrate decides to examine witnesses without Public Prosecution Service and the defense being present, it's quite conceivable that several rounds of written questions may be needed for some witnesses. And it goes without saying that this will have an impact on the time it takes for the examining judge to hear witnesses. For witnesses that have not been heard before by the examining magistrate, an assessment will have to be made as to how this process should be managed in practical and procedural terms, and time-consuming procedures under Article 226 of the Code of Criminal Procedure may have to be followed. In many cases, the examining judge will have to find an extremely discreet manner to acquire the necessary international legal assistance for these examinations. It's clearly vital that the examining magistrate can start this important task as soon as possible. And a guiding principle, obviously, is that the right to examine a witness on the part of defense needs to be facilitated. Given the exceptional security risks in this case, careful account must be taken of a fair weighing of the interests at stake when determining how the defense will be able to exercise that right. In this case file, we see no witnesses who could be viewed in due course as sole and decisive witnesses within the meaning of case law of the European Court for Human Rights. The anonymous witnesses in this case file are a considerable group of witnesses who in particular can provide statements about the delivery and removal of the Buk Taylor and the firing of the Buk missile. There is no single witness in the case file in its current form whose testimony could be considered potentially decisive for a conviction. This circumstance is relevant to weighing, on the one hand, the interests of the defendants in having witnesses examined, and, on the other hand, the interests of the witnesses in giving evidence in a safe manner.
The case file contains statements from witness M58. This witness eventually put their name to a statement, but at this stage of the proceedings, we see no reason to disclose that name. This witness states in summary that in the summer of 2014, as a Russian volunteer, they were active in a separatist unit in the self-declared Republic of Donetsk. They indicate that on 17 July 2014, at the time flight MH17 was downed, they were at a crossroads south of Snishne in the vicinity of a Buk Taylor at the moment a missile was launched. Together with others, they were tasked with guarding the site. This witness also talks about other separatists at the launch site and mentions various details of that location. M58 states that those present were initially pleased because they were told that a military transport aircraft had been shot down. When the first people returned from the crash site, however, they mentioned that it was a civilian aircraft. In view of the content of M58's statement and personal situation, specific measures have been taken to protect M58. These protection measures have an impact on M58's further effective availability to the investigation, the court, the public prosecution service, and the defense. For this reason, in October 2019, M58 was examined by the examining magistrate. These sessions took place without the defense or the public prosecutor being present and were filmed audiovisually. Measures were taken to conceal M58's identity on the recording. Experience shows that it is beneficial to the safety of a protected witness to examine them as soon as possible because the Public Prosecution Service is applying for a further investigation by the examining magistrate so that the Public Prosecution Service and, if desired, the defense can put additional questions to this witness. The witness's statements are consistent and clear. However, some subsidiary points still leave questions open. For example, concerning the dates of various events in the run-up to 17 July 2014, the Public Prosecution Service would also like to ask additional questions about what the witness observed at the launch site. For example, concerning those people who were present. The witness addresses these points at certain moments. He states, for example, that he recognized Russian accents among the military personnel present at the launch, that Russian military personnel were present at the buck, and that he heard from his companions that people from the FSB were present at the shooting down of the aircraft. The audiovisual recordings of the examination of M58 are in the possession of the examining magistrate. The Public Prosecution Service requests that the court instruct the examining magistrate to compile relevant parts of the recordings that, having regard to the security measures in place to protect the witness, may be added to the case file and, if desired, could be shown in court. The examining magistrate should take account of the positions of the Public Prosecution Service and the defense when making the selection based on the official report of the statement, the relevant parts of the examination. We assume that safety considerations will preclude examining M58 in court. Prior disclosure of the time and place of the examination in court and the associated travel required would pose an excessive security risk. If the court were to consider an examination in court, we would ask the court to consider seeking the views of the examining magistrate in time as to whether this can be done responsibly. This is because of the importance, for security reasons, of not examining a witness like MSB more often than necessary. That takes me to witnesses S21 and S07. That's how they're identified in the case file. Witness S21 states, in summary, that in the summer of 2014, this witness belonged to a separatist unit operating in the Donetsk area. This witness reported to Defendant Kharchenko. S21's duties included manning checkpoints, patrolling and guarding locations and assets. On the day that flight MH17 was downed, S21 was deployed together with others in the evening to transport a buck teller from Snizhne. They transferred the teller to others in the county of Debaltseve. Witness S07 has stated that They too were active in the period in question in a separatist unit under the aegis of Kharchenko. S07 is not very specific about his activities on 17 July 2014. S21 has stated that S07 was also present when the buck teller was removed after the downing of flight MH17. S07 did not acknowledge this when interviewed. The Public Prosecution Service therefore wishes to question S07 further on this point and to put S21 statements to S07. The Public Prosecution Service would also like to ask S21 questions arising from the statements given by S07 and witness M58. For example, M58 describes the situation at the launch site and in the surrounding area and the people who were present. S21 was also present at these locations. S17, S21, and S32. Witness S17 was interviewed in 2015. In witness S17's statement, it is described that before the downing of flight MH17, they were shown a video on 17 July 2014 in which an air defense system resembling a tank could be seen. The person who had recorded the video had done so earlier that day. In the meantime, of course, several images from 17 July 2014 showing Buck Taylor have come to light. The Public Prosecution Service would like to ask S17 to determine whether the video concerns one of these images. Witness S2017 was also interviewed in 2015. Based on this statement, at two different locations on 17 July 2014, they saw a buck teller. One of these locations is Ilitch Avenue in Donetsk. A photograph of the buck teller was also taken there. S27 also describes the people who were with the buck teller and recognizes. Would like to interview S2017 in more detail about the grounds on which S27 concluded that a buck teller was involved. And at the current stage of the investigation, the Public Prosecution Service would also like to ask S27 more specifically about the people with the buck teller. S32 stated in 2016 that in July 2014 they filmed a book with an accompanying convoy using their dashboard camera and had someone else upload it to YouTube. All three of these witnesses were interviewed quite some time ago and have not yet been interviewed by the Public Prosecution Service. With respect to all three witnesses, we'd intended to apply earlier, before July 2019, for them to be examined by the examining magistrate based on 226A of the Code of Criminal Procedure. When we were drafting these applications, however, it transpired that such an examination would no longer be possible because speaking to the witnesses would be difficult because they could no longer be contacted or could not be examined by the examining magistrate in a manner that would ensure their safety. This situation may have changed with the passage of time. We believe it is necessary for the examining magistrate to hear these three witnesses now, if possible, in a safe manner, either in accordance with the 226A procedure in the Code of Criminal Procedure, or otherwise further questions can then be put to the public prosecution, can be put by the Public Prosecution Service and the defense, and if the examination is conducted in accordance with a procedure in 226A of the Code of Criminal Procedure, the examining magistrate may carry out an investigation of witness reliability based on 226A DCCP. The statements of all three of these witnesses are important as regards to assessing the video and photographic materials relating to the buck teller as in the case file. As we have just explained, doubt has been cast in some viewing the wreckage, giving the court, the defense, and the public prosecution service the opportunity to see the wreckage of MH17 would deepen their insight into the forensic case file. That way, participants in the proceedings would be able to get a sense of the perforations and pitting on the left side of the aircraft and of the various pieces of wreckage where the fragments struck and were removed later that show similarities to a Buck missile of the 9M38 series. A viewing would help create a broader impression of the damage, as it is difficult to capture it effectively in photograph. The case file includes a 3D reconstruction of the wreckage. It provides a clearer picture than photos do, but still does not give the same impression as viewing the wreckage in person would. The reconstruction made by the DSB of the front of the aircraft is in Gilserijen, comprising the outside of the cockpit, the business class section, and part of the economy class. Most of the pieces of wreckage in which fragments were found that match parts of a Buck missile can be seen in the reconstruction. Only the left wing, in which several of such pieces were found, is stored at a different site. The same holds true for the various larger and smaller fragments that match various parts of a Buck missile, both visually and in terms of their composition. They were removed not only from the wreckage, but also from the bodies of victims and the crew's flight documents. Larger parts were found separately at the crash site. These parts, which are thought to be from a missile, are stored elsewhere. The same holds true for the parts of the various dismantled and detonated reference missiles from Ukraine and Finland, which were compared to the fragments found and the aluminum witness plates used for the arena tests. We believe the photos in the case file provide a clear enough picture of these, so they do not need to be viewed in person. If necessary, smaller fragments may be shown in the courtroom at a later date. A viewing of the reconstruction will suffice to create a broader picture of the damage. We therefore applied to the court to move the hearing to the hangar at Gilserijen Air Base at a date to be determined. If the court prefers to view the other items we just mentioned that are stored elsewhere, it may, of course, decide that ex proprio motu. Such a viewing will require the defense to be familiar with the forensic case file. A viewing could therefore also take place in June or even later. In this case, too, we think it would be desirable for the court to make a decision now so that the necessary logistic preparations can be made and the further scheduling hearings may take this into account. That takes us to access to documents. As we have noted, the Public Prosecution Service will actively offer the defense access to various documents not in the case file because we did not consider them relevant, but about which the defense may believe otherwise. After all, in assembling the case file, we were not yet able to take into account any defense from Pulatov, as none has been disclosed to date. The defense is also free to request, giving reasons, access to other documents not in the case file to substantiate specific defenses. The case file sets out why several specified documents have not been included. If the defense wishes to access such documents, of course this is possible. The Public Prosecution Service would refuse this only if such a request if refusing such a request were necessary on serious grounds, such as the safety of witnesses or the interests of the ongoing investigation. into other persons of interest. If the Public Prosecution Service and the defense disagree as to whether such access can be given, the court will decide to expedite these proceedings. The Public Prosecution Service proposes that the examining magistrate be instructed to rule in between hearings on behalf of the court, or any objection the defense may lodge against any refusal on the part of the Public Prosecution Service to give them access. We believe that this too would be in the interest of the investigation and in the progress of the trial. It may also be in the interest of the defense to have a translation of case documents. Before this hearing, the Public Prosecution Service provided a Russian translation of the notice of summons and accusation and the general account. This account is a detailed summary of the case file, comprising, in the Dutch version, 147 pages. This was quite time-consuming. In addition, the Public Prosecution Service has undertaken this translation is nearly complete after the defense notified the court that they would act as counsel. The Public Prosecution Service also added to the case file the audio files of the intercepted phone conversations most relevant to believes that these documents will provide the defendant with sufficient insight into the charges and the evidence adduced by the Public Prosecution Service, able to carefully determine the course of action he wishes to adopt during the proceedings. It may then be assessed based on specific substantiated request whether it is in the interest of the defendant to have Russian translations of additional documents. Before this hearing, the Public Prosecution Service already discussed with the defense that any with 32A1 of the Dutch Code of Criminal Procedure and European legislation, according to the relevant European directive, these must be documents essential to ensure that the defendant is able to exercise their right of defense. We propose that the court instruct the examining magistrate to decide in between hearings on behalf of the court regarding any requests for translation by the defense to expedite the proceedings.
Like the defendants, the victims next of kin also have certain rights. For instance, they too are entitled to gain access to case documents, insofar as that is in their interest. Article 51b, paragraphs 1 and 6 of the Code of Criminal Procedure. Certain documents may be relevant to any statement they wish to make in exercising their right consequences for the present criminal proceedings. On account of the exceptional media interest in this case and the large number of next of kin, there's a real chance that case documents may end up in the public domain. We believe it would not be in the interest of due process if this were to occur before those case documents had been examined at a public hearing. The Public Prosecution Service therefore adapts a restrictive approach vis-à-vis the provision of case documents to next of kin, assessing each request individually in terms of whether there are arguments in favor of deviating from that general restrictive approach. In view of the interests of the next of kin, we do believe we can provide a copy of the summary of the investigation as soon as the consideration of the merits has taken place. We have previously undertaken to do so.
We have also undertaken to ensure, in any event, that they will receive that summary no later than 4 weeks before they are asked to submit their claim. To that end, sufficient time, at least 4 weeks, will have to be scheduled between the completion of the consideration of the merits and the submission deadline for the claims of injured parties. Now that the hearing is underway, the court will have to decide on any requests for access to or copies of case documents. We hold the view that the rights of next of kin are best served when a substantial presentation of several parts of the case file is given during the preliminary phase of the trial. We will elaborate on this. In addition to the right to information, next of kin also have the right to be heard in court during the criminal proceedings and the right to claim damages. The next of kin have been asked about this, and as it stands, 49 persons wish to exercise their right to be heard in court, 84 wish to submit a claim as an injured party, and 82 wish to submit a victim impact statement. This is just the first estimate. All next of kin are free to change their minds on this matter. In the interest of the process, it would be our preference for the next of kin to exercise their right to be heard in court before the closing statements. The same goes for the first clarification of the claim for damages. We would ask the court to take the above into account when scheduling the rest of the trial. We are concluding by a preview to the assessment of the merits of the case. It is partly influenced by the way efforts to establish the truth in this case have been obstructed over the years since 17 July 2014. Over the past few years, public awareness of public debate, democratic processes and the rule of law these days, states try to exert influence and mislead by means of manipulated information. Democratic state and an open society. Like the European Union and many other countries, the Dutch government has taken measures to counter the dangers of disinformation campaigns. After MH17 was shot down, a disinformation campaign began that continues to this day. Using open sources and intercepted telephone conversations, Station Live News reported as follows on the 17th of July from 1634, which is within 15 minutes of the crash. Rebels inform us that they have succeeded in downing another transport aircraft of the Ukrainian Air Force. This occurred above the city of Tarets on the self-proclaimed Republic of Donetsk. This was done about 5 o'clock Moscow time. An AN-26 was flying over the city. Suddenly, a missile penetrated the aircraft. An explosion followed and the aircraft began to fall. Black smoke could be seen in the air. Mogila Hill. These areas are controlled by rebels. It can be noted that in this early media coverage, important elements are mentioned that came to be established later on in the investigation. The involvement of the rebels, who apparently claimed to journalists themselves that they shot the aircraft down, the use of the missile, and the link with the area around Schnetje, which was controlled by the rebels. Only the nature of the downed aircraft was incorrect. There is more evidence in the case file that the DPR openly claimed to have shot down an aircraft shortly after the crash of MH17. For instance, a photographer who was in the area described in a World Press video interview in 2017 how he was phoned by the press spokesperson of the separatists after the crash of MH17, who told him that they had shot down a military aircraft belonging to Ukraine. He received this telephone call before it became known what type of aircraft had been shot down. When it became clear in the following hours that the target hit was not a military aircraft but civilian flight MH17, the claim by the rebels and the eyewitnesses about the missile were gone entirely. Instead, it was reported at 6:02 that MH17 had been shot down with an S-300 missile system belonging to the Ukrainian armed forces. Just under a half an hour later, the Russian Ministry of Defense adopted this line of reporting, and it happened on the 21st of July 2014 in a press conference, to which we have referred to before. During that press conference, the Ministry suggested two scenarios, saying on the one hand that MH17 may have been shot down by a Ukrainian fighter aircraft, and on the other hand pointing to a Ukrainian Buk system. From then on, both scenarios were maintained by, among others, the Ministry of Defense, Buk manufacturer Almaz Antey, the Russian Criminal Investigation Authorities, the Deputy Prosecutor General and the Minister of Foreign Affairs. Until mid-2015, an attack by a Ukrainian fighter aircraft was the dominant scenario. Once the DSB published its draft and final report, however, the emphasis shifted to a Ukrainian Buk missile. Various interpretations were given as to what type of missile and what type of warhead were thought to have been used to the background. That is the date on which it was announced that Russian radar data had been found, and that those radar images did not show a fighter aircraft. From then on, the Ukrainian Buk missile became the dominant scenario. In 2018, it was confirmed by the presentation of documents that allegedly show that the Buk missile responsible was delivered to a Soviet Union in Soviet Ukraine. Deputy Prosecutor General in early 2019. He too pointed to the evidence of it being a Ukrainian missile. Nevertheless, the Russian Federation has continued to keep both options open. Its response in the proceedings before the ECHR only went as far as referring to the alleged shooting down of MH17 by a Buk missile. To this very day, the Russian authorities have never taken a final position solely at casting doubt about the evidence pointing to a Russian Buk missile and at disqualifying the JIT's incorrect information about satellite and radar images, while refusing to provide any information about the bacteria that was identified in the JIT's investigation as being the system used to shoot down MH17. Dutch Minister of Justice and Security to transfer the prosecution of the 3 Russian suspects to the Russian Federation. Of the subjects about which disinformation is deliberately being disseminated is MH17. Security has said before that in the run-up to and during the criminal proceedings with regard to MH17, we must be prepared. Documents of the JIT's investigation were published on a website. One of those documents is part of These are 2 photos originating from Paris, much of a teller on a trailer behind a Volvo lorry in Donetsk, a photo of a teller on a trailer in Tariet, and a photo of a teller moving under its own power in Schnitze. The leaked part of this report mentions the metadata of these files. Modified date of the files is earlier than the creation date every time. That is not a conclusion about actual manipulation themselves. Various reasons could explain why this is so. More important is the fact that over the years stills were taken. Investigation of this video has shown that according to the metadata, it was shot on the 17th of July 2014 at 10:23 at a GPS location on Makeyevka Highway in Donetsk. On the NFI investigated this video and found no indications of manipulation. In addition, the presence of the teller at this location is confirmed, which showed that these photos were made public as early as 17 July 2014. That is earlier than the Australian report had been able to establish on the basis of has now been superseded by all the validation that has taken part of the report was not published on the website. According to the information in the original report, it's confirmed by other sources in the case files. Apparently, the website saw reason to publish only those investigation results that could be used to suggest visual material had been manipulated, parts of the report that confirm the authenticity of a video were not which are in the case file. These are official reports by the Netherlands Defence Intelligence and Security Service, MIVD, that provide information about the locations of Ukrainian and Russian BUK systems in the region where MH17 was shot down. This military information is limited to locations where, over longer periods, activities have been observed in June and July 2014. So, the MIVD does not conclude that there was no Russian BUK system present in eastern UK. Used and removed immediately fell outside the scope of the MIVD's observations as described in the reports. Last Saturday, the makers of this website have made public new documents. These are not relevant to this trial. What is relevant is the investigative work that has actually been conducted. You will find this in the case files. It is apparent that we can expect further publications like these in the course of the to all of the published documents. So far, none of these 4 JIT states have been able to identify any leaks. However, there are indications of previous cyber operation that had targeted the targeting the MH17 investigation. This witnesses has been stored at another, more heavily secured digital location than the documents that have been disclosed thus far. "5 years now, places a heavy strain on many of the next of kin. As we've already stressed in our opening statement, the next of kin of victims newspaper last week. On 17 July is insufficient. That is the immensity of the MH17 tragedy. Just as immense is the importance of this trial. The question so lays the necessary legal foundation for justice and accountability. For many next of
public scrutiny of the investigation or its results to secure accountability in practice as well as in theory. Mede
in 2006 the right of next of kin and the wider public to the truth following grave human rights violations. That includes not only information about the circumstances but also about the progress and results of the investigation.